If you are a green card holder or you have a green card application in progress, what you are about to hear could directly affect your future in the United States. USCIS has now confirmed that a major green card rule change is starting next month, and most people have no idea how serious this is. This is not a rumor, it is not speculation, and it is not something you can afford to ignore. Thousands of immigrants are continuing with their plans as usual, believing the same old rules still apply, and many of them are about to be blindsided. By the time they realize what has changed, it may already be too late. That is exactly why you need to stay with me through this entire video, because missing even one part of this update could put your status at risk. Over the past few weeks, USCIS has quietly finalized changes that reshape how green card cases are reviewed, monitored, and enforced. On the surface, nothing looks dramatic. There is no loud announcement, no emergency press conference, no headlines flashing on television screens. But behind the scenes, the rules that officers use to evaluate green card holders and applicants are shifting in a way that gives the government more discretion, more data, and more authority than before. And when USCIS confirms a change like this, it is never accidental. It means enforcement is about to follow. Most immigrants assume that once they receive a green card, their status is safe as long as they avoid obvious violations. That assumption is becoming more dangerous by the day. The new rule change starting next month is designed to close gaps that many people did not even realize existed. USCIS is no longer just looking at whether you technically qualify on paper. They are expanding how they evaluate intent, behavior, patterns, and consistency across your entire immigration profile. What you do, how you live, how often you travel, how you file taxes, and how you represent yourself across different government systems now matters more than ever. One of the biggest mistakes green card holders make is believing that enforcement only happens when someone does something extreme. That mindset is exactly what gets people into trouble. USCIS does not need a dramatic violation to take action. They only need enough indicators to believe that your situation no longer aligns with the expectations of permanent residents. And under the new rules starting next month, the threshold for scrutiny is getting lower, not higher. This change affects multiple categories of people at once. It affects current green card holders, especially those who travel frequently or spend extended time outside the United States. It affects people with pending adjustment of status applications who assume that approval standards will remain the same. It even affects future applicants because officers will now be trained to apply stricter consistency checks when reviewing case histories. In other words, decisions will increasingly be based on patterns, not just forms. USCIS has made it clear that the goal of this change is to ensure that permanent residence actually reflects permanent residence. That sounds reasonable on paper, but in practice, it gives officers wide discretion. Discretion is where most problems begin, because discretion depends on interpretation, and interpretation depends on judgment. Two people with nearly identical situations can receive very different outcomes depending on how their case appears under this expanded review framework. What makes this especially dangerous is that many immigrants are operating on outdated assumptions. They are relying on advice from years ago, stories from friends, or information that applied under previous enforcement priorities. USCIS is signaling that those days are over. The system is being updated to identify inconsistencies faster, share information more efficiently between agencies, and flag cases that previously might have passed without issue. If your situation falls into a gray area, that gray area is shrinking. Another critical factor is timing. Because this rule change starts next month, many people are already locked into plans they made under the old understanding. Travel plans, job changes, address changes, filing decisions, and even how long someone stays abroad can suddenly take on new significance. The problem is not that people intended to violate any rules. The problem is that the rules they thought they were following are no longer being interpreted the same way. USCIS has also confirmed that officers will be given updated internal guidance. That matters because internal guidance shapes how interviews are conducted, how questions are asked, and how officers assess credibility. When guidance changes, outcomes change. Applicants may find themselves facing more detailed questioning, requests for additional evidence, or unexpected delays, even if their case seems straightforward. This is why paying attention now is so important. Once these changes are fully implemented, USCIS will not accept ignorance as an excuse. They will assume applicants and green card holders are aware of their obligations and expectations. If a case is flagged under the new system, fixing it afterward is far more difficult than preventing the issue in the first place. Throughout this video, I am going to break down exactly what this major green card rule change involves, why USCIS is implementing it now, who is most at risk, and what practical steps you need to take to protect yourself. This is not about panic. It is about preparation. The immigrants who stay informed and adapt early are the ones who stay safe. The ones who assume nothing has changed are the ones who get caught off guard. So before you make your next move, before you book travel, before you assume your case will be treated the same way it would have been last year, you need to understand what is coming. Because starting next month, USCIS is playing by a different set of rules, and whether you realize it or not, your future may depend on how well you understand them right now. Now let's talk about what this rule change actually looks like in real life, because understanding the mechanics is where most people get confused. USCIS is not introducing a single new form or a single new requirement that you can easily point to and say, "This is the change." Instead, they are reshaping how green card cases are evaluated across multiple touchpoints. That is what makes this shift so powerful and, for many people, so risky. Under the confirmed changes starting next month, USCIS is placing much heavier emphasis on consistency. That means consistency between what you say on different applications, consistency between your immigration filings and your tax records, consistency between your travel history and your claimed residence, and even consistency between your stated intentions and your actual behavior over time. In the past, inconsistencies were often overlooked unless they were obvious or extreme. Going forward, those same inconsistencies are far more likely to trigger questions, delays, or negative decisions. One major area where this will be felt immediately is travel and physical presence. USCIS has made it clear that green card holders are expected to maintain the United States as their primary home. While this has always been the legal standard, enforcement has varied over the years. The new rule change signals a return to stricter enforcement, supported by better data and closer coordination with other agencies. Travel patterns that once passed without comment may now be flagged for review. This does not mean you cannot travel. It means your travel must make sense when viewed as part of your overall life in the United States. If someone spends long periods abroad, works remotely from another country, or appears to have stronger ties outside the U.S. than inside it, officers are now more likely to question whether permanent residence is being maintained in good faith. The system is designed to look at the big picture, not just isolated trips. Another area heavily affected by this change is employment and income. USCIS is increasingly cross-checking information with tax filings and employment records. If your green card application or renewal suggests that you live and work in the United States, but your tax filings tell a different story, that discrepancy can raise red flags. Filing taxes as a non-resident, reporting most income from abroad, or showing little to no U.S.-based economic activity can undermine claims of permanent residence. This is especially important for people who believe they can keep their green card while effectively living elsewhere. Under the new approach, that strategy is becoming far more dangerous. USCIS is sending a clear message that permanent residence is not a status you park and revisit occasionally. It is a status that requires ongoing, demonstrable ties to the United States. Pending applications are also affected. Adjustment of status cases, removal of conditions, and even renewals are likely to see increased scrutiny. Officers will be trained to look backward as well as forward. That means past travel, past filings, and past behavior can all be examined more closely, even if no issues were raised at the time. Something that went unquestioned 2 years ago may now be reinterpreted under the new guidance. Interviews are another area where applicants will notice changes. More detailed questioning, more follow-up requests, and a greater focus on intent are all expected. Officers are being encouraged to probe deeper when answers seem vague, inconsistent, or rehearsed. This does not mean interviews will be hostile, but they will be more thorough. Applicants who are unprepared or who rely on assumptions rather than facts may struggle. What makes this especially challenging is that many immigrants believe they are compliant simply because no one has ever told them otherwise. Under the new rules, that passive approach is risky. USCIS is shifting from a reactive model to a proactive one. Instead of waiting for a clear violation, the system is designed to identify potential issues early and push cases into closer review. Once that happens, the burden often shifts to the immigrant to prove compliance. It is also important to understand that this change is not happening in isolation. It is part of a broader trend toward tighter verification and data sharing across government systems. Information from USCIS, Customs and Border Protection, the IRS, and other agencies is increasingly interconnected. What you report in one place does not stay in that place anymore. Inconsistencies are easier to detect, and explanations are expected to align across systems. This is why preparation matters more than panic. The immigrants who will be most affected by this rule change are not criminals or bad actors. They are ordinary people who relied on outdated advice, misunderstood how discretion works, or assumed that silence meant approval. The new system is less forgiving of assumptions and more focused on documentation and patterns. If you are a green card holder or applicant, the key takeaway from this section is simple but critical. USCIS is no longer just checking boxes. They are evaluating lifestyles, behaviors, and long-term intent. The closer your real life matches what permanent residence is supposed to represent, the safer you are under the new rules. The more your situation lives in a gray area, the more attention it is likely to attract. In the next section, we are going to focus on who is most at risk under this change and what concrete steps you should be taking right now to protect yourself before next month arrives. Understanding the rule is important, but knowing how it applies to you personally is what ultimately makes the difference. Now let's focus on who is most exposed under this new green card rule change, and more importantly, what you should be doing right now to protect yourself before next month arrives. This is the part that separates people who stay safe from people who later say they wish they had acted sooner. The group most at risk is green card holders who spend significant time outside the United States, even if they believe their reasons are valid. This includes people caring for family members abroad, managing businesses overseas, working remotely, or splitting time between countries. While these situations may feel reasonable on a personal level, USCIS evaluates them through a legal lens. Under the new rules, extended absences and frequent travel patterns are far more likely to trigger scrutiny, especially when combined with weak documentation of U.S. ties. Another high-risk group includes green card holders who file taxes incorrectly or inconsistently. Filing as a non-resident, failing to file at all, or reporting most income from outside the U.S. sends a strong signal that the United States may not be your true home. Under the updated enforcement approach, tax records are no longer treated as a separate issue. They are a core indicator of residency intent. Many people underestimate how damaging tax inconsistencies can be until they are already facing questions from immigration officers. People with pending applications also face increased risk. If you have an adjustment of status case, a removal of conditions petition, or a renewal in progress, your entire history can be reviewed under this new framework. Officers are not limited to looking at your current situation. They can and will examine past behavior, travel, and filings to assess whether your overall pattern supports permanent residence. If there are gaps, contradictions, or unexplained decisions, those issues may now surface. Conditional green card holders need to be especially cautious. Because their status is already temporary and dependent on future approval, any factor that raises doubt can complicate the process. Long absences, weak evidence of shared residence in marriage-based cases, or unclear employment histories can all become bigger problems under stricter review standards. What once resulted in a routine request for evidence could now lead to delays or denials. There is also a group of people who do not realize they are at risk because nothing has gone wrong yet. These are green card holders who have been living in a gray area for years. Maybe they travel often but have never been questioned. Maybe they live abroad part of the year but return just often enough to feel safe. The danger for this group is that the new system is designed to identify patterns over time. Past luck does not guarantee future safety. In fact, patterns that were previously ignored may now stand out clearly. So, what should you be doing right now? The first step is to evaluate your situation honestly. Look at your travel history, your tax filings, your employment, and your living arrangements. Ask yourself whether, if reviewed as a whole, your life clearly points to the United States as your primary home. If the answer is uncertain, that uncertainty is a warning sign. The second step is to strengthen your U.S. ties wherever possible. This means maintaining a real U.S. address, not just a mailing address. It means having active U.S. bank accounts and actually using them. It means keeping your driver's license current, maintaining employment or business activity in the U.S., and ensuring your tax filings accurately reflect resident status. These details matter far more under the new rules than many people realize. If you anticipate extended travel, planning is critical. This may include adjusting travel schedules to limit time abroad or applying for appropriate documentation well in advance. Last-minute decisions are risky because many protective options require time, presence in the U.S., and advance preparation. Once you are already abroad for an extended period, your choices become much more limited. Documentation is another key area. Under the new enforcement approach, being compliant is not enough if you cannot prove it. Keep organized records of your ties to the United States. This includes leases or mortgages, utility bills, employment records, tax returns, and any evidence that shows ongoing life in America. If you are questioned, having immediate access to clear documentation can make a significant difference. It is also important to be mindful of consistency in everything you submit to the government. Information provided to USCIS, the IRS, and other agencies should align. Inconsistencies do not always indicate wrongdoing, but they do invite questions. Under the new rules, those questions are more likely to be asked and taken seriously. For some people, consulting an immigration attorney before problems arise is a wise move. This is especially true if you have a complex history, extended absences, or prior issues. A proactive review can help identify risks and address them before they are flagged by the system. Waiting until you are already under scrutiny often limits your options and increases stress and cost. Finally, this rule change highlights why many green card holders choose to pursue U.S. citizenship when eligible. Citizenship removes many of the uncertainties tied to travel and residence. While naturalization has its own requirements, it provides long-term security and freedom that permanent residence does not. For those who qualify or are close to qualifying, moving forward with citizenship may be a strategic decision under a stricter enforcement environment. The most important message to take away is this. USCIS has confirmed that a major green card rule change is starting next month, and it is not focused on paperwork alone. It is focused on behavior, patterns, and intent. The people who adapt early, stay informed, and align their lives clearly with permanent residence expectations are the ones who will navigate this change successfully. Those who assume the old understanding still applies are taking a risk they may not fully appreciate until it is too late. Preparation is not panic. Awareness is not fear. Understanding how these rules work and adjusting accordingly is how you protect your future in the United States. This change is coming whether people are ready or not. The question is whether you will be among those who saw it coming and acted in time.